Canada's new anti-spam law comes into force on July 1st, 2014, and will cover all electronic messages including email, social networking accounts, and text messages, plus much more. What does it mean for you as a business owner when communicating with current and potential clients? What are the guidelines and penalties? What do you need to know, and how should you prepare? Hi, my name is Debbie Lapointe. I'm a small business owner who began researching the Canadian government's new anti-spam law a year ago, when the spam I was receiving in my inbox became a daily source of frustration. I'm not associated with the new anti-spam program, but I'm happy to share what I've learned with other business owners who will be impacted by the changes. So what is the Canadian anti-spam legislation? It's a tough new law meant to crack down on unwanted emails and electronic messages, including texts and tweets. Experts describe it as the broadest legislation of its kind in the world. Businesses selling or promoting products or services will need to prove that they have consent to reach out to new, existing, and potential customers using commercial electronic messages, also known as SEMS. Canada is the last of the G20 countries to put forward this type of legislation, which is part of international agreements. Anyone who makes use of commercial electronic messages is involved with the alteration of transmission data, or who produces and installs computer programs needs to be aware of this law. Some questions to ask yourself. Do you use email, text messages, social media, or instant messaging to send commercial or promotional information about your organization to reach customers, prospects, and other important audiences? Do you install software programs on people's computers and mobile devices? Do you carry out these activities in or from Canada? If the answer is yes to any of these questions, then this law does apply to you. The law is not limited to just Canadians. It takes effect anytime a Canadian computer is used to access any commercial electronic message. So if someone in the US or overseas sends a SEM to Canadians, all these rules apply. According to the CRTC, if the spammer is offshore, we have the ability under the law to cooperate with foreign governments, to share information, and to bring proceedings together against individuals that are offshore. The legislation does not apply to non-commercial activity, to voice, fax, or robocalls, or to broadcast messages including tweets and posts. The definition of an electronic address is an email account, a telephone account such as a cell phone, an instant messaging account, or any other similar account. There are 3 simple rules to remember. You must have expressed or implied consent to send a message. You must clearly and simply identify yourself and anyone else on whose behalf the message is sent. And in every single message you send, you must provide a way for the recipient to unsubscribe from receiving messages in the future. There are 2 types of consent. Express consent is when the recipient has said yes to receiving your commercial electronic messages, or if someone has opted in on your website for a specific purpose. Business owners need to document to show that they're in compliance with the legislation, and they need to demonstrate how they obtained that consent. The other type is implied consent. If you can show that you have an existing business or non-business relationship, for instance, if you've had business with the recipient within the last 2 years, the business has to be able to prove the business deal and to track the timing. Or, did that recipient disclose their address to you? Is the address published? And is there a statement saying they don't wish to be contacted? You need to track how you obtained consent for each individual that you're sending your electronic messages to. And if you send a message after July 1st asking consent to put them on your distribution list, that email is also considered a commercial electronic message. A little tip from Elite Email: getting consent can be written or oral. If companies want to do it through email, they need to reach out to their clients and customers by July 1st to have them opt in. That could include the customer checking a box or opting in on your website. If you send that email after July 1st, that will be considered an offense. If you don't have consent by July 1st, you need to get it through other means such as phone call or snail mail. There are special cases such as third-party referrals. You can refer a prospective client to another person if you already have an existing relationship with the prospective client. If you're the one receiving the referral, you're allowed to send one electronic message to the prospective client, and that message must include the full name of the person who made the referral. When is consent not required? When sending quotes or estimates, messages that facilitate or confirm a transaction, messages that provide warranty, recall, safety, or security information, messages that provide information about ongoing use or ongoing purchases, subscriptions, memberships, accounts, loans, or anything similar, employment relationships or benefit plans, and messages that deliver product, good, or service, including updates and upgrades. Basically, any messages where you're responding to someone who's requested a quote or estimate, or that relates to a product or service that they've already purchased. The legislation does not apply to messages within or between businesses where there's an ongoing relationship in response to a request via a closed messaging system such as proprietary systems, and any messaging systems where an ID is required and there's unsubscribe included in the platform. Legislation does not apply to registered charities raising funds or by political candidates and organizations looking for contributions. When are messages exempt? The legislation does not apply to messages if you have a personal relationship with the recipient or if you have a family relationship with the recipient. The major differences between the Canadian anti-spam law and the U.S. anti-spam law is that the U.S. anti-spam law covers email only, and they can send one unsolicited email with an option to opt out. The Canadian legislation covers all electronic messages, including email, text messages, tweets, and the installation of programs. And we must have consent to send all our messages. Most of the Act comes into force July 1st, 2014. You'll need consent from any new client, and each commercial electronic message must include identification and a way for them to unsubscribe. They've applied a transitional period of 3 years for implied consent. There are 3 things to think about when sending out messages. Think about who you're sending your messages to. Did they give you consent? Do you have a record of this consent? Did they say, "Oh yes, please contact me"? Did they publish their contact information online? Or did they give you a business card? Look very closely for any don't contact instructions. And this means no automated address generation or collecting. You may want to keep that in mind when you're considering buying lists. Do you have an existing business or non-business relationship, such as customers, clients, associates, donors, supporters, volunteers, or members that you've done business with from the last 2 years? Think of the type of messages you're sending. Is it sent to an electronic address, such as an email, instant messaging, cell phone for text messages? Is it commercial or promotional? Does it include any marketing messages or sales or offers? And you have to ensure that no part of your message is false or misleading. Think about what you must include. You need to identify your name and business, the name of anyone else on whose behalf you're sending the message, a current mailing address, and you must also include a phone number, email address, or web address. And you must ensure that all the information above is accurate and valid for a minimum of 60 days after sending it. You must include details on how to unsubscribe in each and every message that you send. And you must ensure that that unsubscribe request is responded to within 10 days or less at no cost to the recipient. It's important to remember that if you use social media to just post or tweet on your own timeline, then that's okay. But if you're using LinkedIn, Facebook, or Twitter account to send private emails to someone which is commercial in nature, then that's considered a SEM under the legislation. So what are the penalties? $1 million for an individual and up to $10 million for companies. The court can award damages for loss or harm, and it could award a separate monetary penalty for each and every violation. The law will be enforced by 3 government agencies: the CRTC, the Office of the Privacy Commissioner, and the Competition Bureau. As of July 1st, you'll be able to report spam and other violations at fightspam.gc.ca. As of July 1st, 2017, there will also be a private right of action, which means that people will be able to start taking legal action against anyone not following the rules. The big concern for businesses is the threat of class action lawsuits. Resources for this presentation are as listed. Please visit the links for further research and resources. I hope you've enjoyed this presentation and that you've found it useful and informative. Thank you for watching.